Okay. Now, in the examination in chief, yes, you prepared your report. If it's in a civil case, then it's quite likely that the report itself will be made real evidence. That is, it will be tendered in evidence, and that means that everybody involved in the case can then use it as evidence. In most criminal cases, the decision maker will never see your report. In most of them, you're still required to answer questions based on your report, but the decision maker doesn't get your report. For that reason, it's important that you discuss what's in your report with your advocate before you go into the witness box. Why? Well, for starters, it's odds on that 5 minutes before you go into the witness box, you'll discover there's a typographical error in the first paragraph that you didn't see in the 20 or so reads that you did beforehand. Why? Because that's life. You'll find a mathematical calculation error in paragraph 2. And you're thinking, I paid people to fix this, and as usual, they've let me down. Doesn't matter. Number of checks you do, it'll always happen. So there are, inevitably, things that you want to fix in your report right as you go into the witness box. These things must be fixed as early as possible. Depending on your advocate, they'll be done either immediately before or immediately after your advocate makes that report of yours part of the evidence. Of course, in a criminal case, it doesn't matter because the decision maker doesn't have that report, but you can go through it and say, how do we do these calculations, all that kind of stuff. Now, in some places that you go to, there'll be a convention that there'll be written reports, and you go into the witness box, you'll take an oath of affirmation, as you did, and then something like this will happen. Mr. Hunt, you wrote a report for this case.
Yes.
And you tell this court that the contents of that report are true and correct?
Yes.
Because you read it this morning?
That's a question?
Yes.
Yes.
You read it carefully?
Yes.
And that's why you're telling me it's true and correct?
Yes.
I tender the report. No objection from the other side, in it goes. That's the only questions you get, and then the other side gets to cross-examine you. Try to avoid having that experience. Always try to find something in your expert report where your lawyer can ask you some additional questions. Why? So there is a couple of minutes at least of the decision maker hearing you being questioned by your own side and you giving answers which you know you can give, so that you're establishing a rapport with the decision maker. Remember, it's all about the decision maker coming to trust you. So they've got to hear you, they've got to see you, form a view about I like them or I don't like them. So that means you can pick out one part of your report and say, ask me some additional questions about that bit. Then your lawyer asks you some additional questions about that bit before the cross-examination starts. Now, for example, on the report that you've got for this afternoon, let's go to the credentials bit, which is the third heading down, first page. And at this point, the author, when the author wrote it, he or she was an associate member of your organisation. Subsequent to the writing of this report, if the usual delays occur in litigation, let's say you've now become a full member. So, I want to handle that because it improves his credibility. So I can do that by saying, Mr. Hunt, at the time when you wrote this report, you were an associate member.
That's right.
And what is your present membership status?
I'm a full member.
And what is the difference between being an associate member and a full member of the association?
I've been assessed as competent for different classes ranges, including class 2 such as fuel.
Okay. All right, so we get out extra information which enhances his credibility to the audience. Going back to before lunch when I talked about that problem definition part of the case. Remember I said on this side you might be the side writing a report to start with, and then this side writes a report that comes back. Now, once the report comes back from here, there may be some insights on the part of people over here, which were not there for good reason when you wrote your first report. That means that when you get to go into the witness box, there are now some things that need to be asked. Notably, from your lawyer, so-and-so for the other side had this to say about this part of your report. What, if anything, do you have to say to counter that? Which should, of course, be something we've discussed. You can then say that. Now, if ever a lawyer says to you, oh, don't worry, they probably won't cross-examine you on it, so you don't need to worry at all, just remember the lawyer's arse is never on fire, but yours may be. Right? And here's a very simple reason why this happens. We run an adversarial system. That means there are winners and losers. There are no draws. As a consequence of it being a winner and loser system, the loser is always pissed off to a greater or lesser extent. Now, the loser is going to receive a number of accounts, yours being one of them, the lawyer's being others. The lawyer, like you, has an interest in staying in business and being solvent. Somebody has to wear the blame for losing the case. It's never the lawyer. All right? For that reason, you always want to make sure that where there are possible problems in your case, that your lawyer brings them out with you, and if a lawyer says, oh, don't worry, it won't come out in cross, you say, no, that won't work at all. We're going to bring it out. And if they say, no, we're not, here is your bottom line. If they don't raise it with you in chief, this is your own lawyer, doesn't raise it with you in chief, turn to the judge, this is where there's no jury, and say, Your Honour, I'm here as an expert. There is an issue, and my first obligation is to assist you. Issue X has not been raised by my lawyer. What would you like to do about it? The judge might say, that's a matter for your lawyer. You say, fine, it's on the record. It's also said in front of your client. If anything goes wrong, not your fault. Always protect yourself. Note, if you are in front of a jury, you must only ever say, if there's something that you think needs to be brought up, Your Honour, there's a matter I need to raise in the absence of the jury. A matter I need to raise in the absence of the jury. The reason you must do it that way is because if you blurt out some perfectly honest and reputable words in front of a jury, that may lead to the jury having to be discharged and the whole trial having to start again. Nobody will thank you for that kind of honesty. Right? So, when you say there's something I need to raise in the absence of the jury, you're saying to the judge, I know enough about this system to know that I'm not going to be the person who aborts this trial, but I need to ask for some direction before we go any further. And then things happen. Not a problem if you do it that way. On to cross-examination. Good cross-examination is what we call closed focus. That is, it presses you as the person being cross-examined to answer a question in one of three ways. Yes, no, or the DKDR response. DK for don't know, don't recall, don't remember. So for this reason, to give a simple example of it, sitting here in front of me is one of your colleagues called Laurie Lim. Sir, your family name is Lim. It's not Chen. Okay? Yes or no, nothing else. If he's had a very liquid lunch, he may have I don't remember. That's different. Okay? Now, because you're being overtly controlled in cross-examination, because in chief we're working as a team, the lawyer and you, to educate, inform the audience. In cross-examination, the lawyer is overtly controlling you. And there's a very particular proposition you must understand here. When you're in the witness box being cross-examined, you will feel exposed, vulnerable, cranky, not properly treated, those sorts of responses. Because you very quickly pick up the vibe that you're not being allowed to say what you want to say. What you need to understand is that for a lot of cross-examination, you are just like a transmission tower, an Optus or Telstra transmission tower, between the lawyer and the decision maker. So, as an example of this, if I can take, sir, alright, have you got the report in front of you? Alright, yep, the one with my name on it.